What you're about to witness is one of the most jaw-dropping courtroom exchanges we've seen in a long time, and it all starts with three simple words: "My name is." That's it. That's the entire battlefield. A criminal defendant, Ryan John Hart, walks into a Michigan courtroom for what should be a routine hearing, and instead of answering one of the most basic questions a judge can ask, "Who are you?" he turns it into a philosophical chess match. And the judge? She is having absolutely none of it. Now, before we dive in, here's what you need to know about this case. Ryan Hart is facing criminal charges in Michigan, including resisting and obstructing, a serious felony. He is represented by a defense attorney named Mr. Seeger. And today's hearing was supposed to address one thing: a motion filed by Seeger to withdraw from the case so that Hart could represent himself. Sounds simple enough, right? Except nothing about this hearing is simple. Because what Ryan Hart is doing, or at least attempting to do, is a well-known legal maneuver used by a group called sovereign citizens. These are individuals who believe they exist outside the jurisdiction of the government, the courts, and the law itself. They often try to distance themselves from their legal name, the one on government documents, by calling themselves things like the representative of the entity, rather than simply confirming who they are. It's a tactic. And this judge sees it coming from a mile away. So buckle up. Because what you're about to watch is a sitting judge methodically, precisely, and with surgical patience dismantle every single one of this defendant's moves, one by one. This is a masterclass in judicial control. Let's get into it.
My name is Ryan John Hart. May I ask a question, Your Honor?
No, you may not.
Mr. Hart.
I have somebody in my hearing room listed as Ryan Hart. State your name for the record, please.
My name is Ryan John Family Hart.
I don't have anyone on my docket listed as Ryan John Family of Hart. I have an individual listed as Ryan John Hart. That's either you or it's not. You get to tell me whether or not that's your name. If it's not, then I need to call a different matter and bring somebody else into my hearing room.
Right here. Stop everything. Did you catch that? The representative of that entity. Not "I am Ryan Hart." Not "Yes, that's me, Your Honor." He said he is the representative of the entity known as Ryan John Hart. This is textbook sovereign citizen strategy. The theory goes like this: when you're born, the government creates a corporate fiction, a legal entity, using your name in all capital letters. Sovereign citizens believe that this entity is separate from the living, breathing human being standing in the courtroom. So by calling himself a representative, Hart is attempting to distance the living man from the legal defendant. Now here's why this is a problem in court: a judge cannot proceed with a case until she confirms the identity of the person standing before her. If Hart refuses to confirm he is Ryan John Hart, not just a representative of one, then legally, the court can't move forward. It's a delay tactic designed to bog the proceedings down in philosophical semantics. But watch how quickly this judge shuts it down. She doesn't take the bait. She doesn't debate the theory. She simply says, you either are Ryan John Hart, or you're not. Period. End of discussion. That's how you handle it. And that's just the opening act.
Your Honor, I'm the representative of that entity, yes.
That's not an answer, sir. Your name is either Ryan John Hart, in which case you're invited to participate in the proceeding today as Ryan John Hart, or you're not Ryan John Hart, in which case I have no use for you to be in this hearing today. So tell me your name so that I can determine whether or not you're the proper person to be called in this case.
My name is Ryan John Hart. May I ask a question, Your Honor?
No, you may not. Mr. Hart, this is not a complicated process, and this process does not get less uncomplicated. When I call a case, I start by identifying the parties that are to the case. When I'm confident I have the correct parties to the case, I proceed then and decide how to go forward. In this case, your difficulty, and I think intentional difficulty, is affecting the ability of the court to be able to proceed and to conduct its business. That's relevant to a lot of points, but most importantly, it's relevant to a pending motion that your attorney filed, presumably on your behalf, but I sense that it's not only on your behalf, it's also on your attorney's behalf. And so we're going to take up that motion. But your difficulty in basic things like telling me whether or not you're the party to a case is thwarting the court's ability to timely
Here's
get
where
its
things
business
get
done.
legally fascinating, because the judge doesn't just say no. She walks through exactly why the motion fails, step by step, under Michigan law. And this is important, because the right to represent yourself, what's called pro se representation, is a constitutionally protected right under the Sixth Amendment. So a judge can't just deny it on a whim. She has to have specific legal justification. And she has 3 separate grounds here. Ground 1, the request wasn't unequivocal. Under the landmark Michigan Supreme Court case People v. Anderson, a defendant must clearly and unambiguously request to represent himself. The judge points out that it wasn't Hart making the request, it was his attorney filing a motion. That's not the same thing. In fact, the attorney's motive appears to be as much about getting himself off a difficult client as it is about Hart's right to self-representation. Ground 2, there's no evidence Hart knowingly, intelligently, and voluntarily understands the maximum penalties he's facing. The judge is required to have that conversation with a defendant before granting self-representation, and she fully expects Hart would play games during that conversation too. Ground 3, and this is the big one, the judge finds that allowing Hart to represent himself would disrupt the orderly administration of justice. Under Michigan law, even if all other factors are met, a judge can deny self-representation if the defendant's conduct would be unduly disruptive to the court. Given Hart's behavior across multiple hearings, she's seen more than enough. The motion is dead on arrival. And frankly, the reasoning is airtight.
I'm turning to the motion now that's before the court today, which is the motion to have attorney withdraw and to have you represent yourself, Mr. Hart. The court does not find that motion to be well placed, and I'm not going to prevent it. And the reason is there are several steps that need to be taken in order for you to be able to assert your right to represent yourself. First and foremost, I must find that your assertion of that right is unequivocal. I don't have that. What I have is your attorney's motion, and I recall very clearly and plainly the last couple of hearings that we've had. A couple of hearings ago, I had findings that I made based upon a competency and criminal responsibility examination. You were found both competent and criminally responsible by the court after assistance from the Center for Forensic Psychiatry and after an in-depth intervention and interview by them. I made the findings, your attorney agreed with them, and the prosecutor agreed. I have not once heard you make any type of unequivocal request at all. What I instead heard when I consider whether or not there's an unequivocal request for you to represent yourself is your attorney explained to me, I think this was 2 or 3 hearings ago now, that he was somewhat conflicted. And these are not his exact words, but this is what I recall from it. He was somewhat conflicted. You had wanted him to file various different motions, which the attorney did not find were supported by law. And the communication that I had in response to Mr. Seeger, again, was some version of this. I told Mr. Seeger that as the attorney, he and he alone chooses which motions are to be filed and which are supportable by fact or by existing case law or by the extension of existing case law. If he can't make those arguments that are good faith supported by law or an extension for the law, then he's not permitted to file the motions. It was at that point that Mr. Seeger then suggested that another solve for him could be that you could represent yourself. In other words, the implication that what Mr. Seeger was making is that if you were representing yourself, you would not be constrained in the way that he is. It would allow you to file whatever frivolous motions, I'm using that word, Mr. Seeger didn't, whatever frivolous motions you wanted to. And so the request to have you represent yourself as made through your attorney is not found, number 1, by the court to be unequivocal in any way. Number 2, I would have to go through with you and be confident that you understood the maximum penalties associated with the crimes. I have every reason to believe that you understand the maximum penalties. But I have every reason to believe that if you and I had a discussion about what those maximum penalties were, you would express confusion and you would not express a knowing, confident, and voluntary understanding of those things. And so I'm not yet even going to get to that second step. I also, of course, would have to, under People v. Anderson, the binding Michigan Supreme Court case regarding waiver of constitutional right to represent yourself, I would have to make specific other findings. And those findings specifically are that I would have to determine after a conversation with you that you acting as your own attorney would not disrupt or unduly convenience or burden the court in the administration of the court's business. What is plain, obvious, and unarguable in over the last 2 or 3 hearings is that if you were permitted to represent yourself, you would make the court's administration of justice difficult, You would delay matters, you would be disruptive, and your representation, therefore, of yourself would be unduly inconvenient to the court and the court's operation of its business. For that reason, even if I found that you otherwise made an unequivocal request, which you haven't, even if I found that you clearly understood and you expressed your waiver knowingly, intelligently, and voluntarily, the court would still not grant your request through your attorney to represent yourself under specific circumstances here. It's my firm finding, based upon the background that I'm aware of, that to allow you to do so would only encourage you to file what are very spurious and frivolous motions. It would waste the court's time, it would waste the prosecutor's time. And although it would waste Mr. Seeger's time to have him remain on, the court also notes that even if there is good cause for Mr. Seeger to withdraw, the Michigan rules of professional conduct allow the court to continue an attorney's appearance and order that an attorney continue on a case even when there's good cause to withdraw. And so I choose to exercise the discretion provided to me under those Michigan rules of professional conduct and the Michigan court rules and Michigan case law in denying any request to have you represent yourself. You are and will remain represented by Mr. Seeger until further order of the court. Mr. Seeger, did you need then some time to discuss the effect of that ruling with Mr. Hart before I decide how this case needs to resolve?
I do, Your Honor. Additionally, Your Honor,
Your Honor, I have something to say. May I speak?
Mr. Hart, you don't get to decide when things are said. That's again part of the issue.
The judge has not let me speak at all in more than three.
Mr. Hart, this will not be an argument. This case will not proceed by me talking over you or you talking over me. Court proceedings by law and by procedure, Mr. Hart, are to be ordered. And they're to be in a specific order, and that order is dictated by the trial court judge. That's me. It's not dictated by an individual who's charged with criminal offenses, you. And so I'm going to exercise
Ladies and gentlemen, the judge just put a loaded weapon on the table, and she made sure Hart understood exactly what it was. Let's break down what she just said. Right now, Hart is out on bond, meaning he's free while awaiting trial. That freedom is conditional. And the judge is telling him directly, come to the next hearing in person, act like a disruption again, and I will revoke your bond. That means jail. Not later, immediately. But why in person? That's actually a strategic move by the judge. She explains it clearly, over video. The only tool she has to control a disruptive defendant is the mute button. That's it. In person? She has the full weight of the court's contempt powers. She can have him removed. She can have him detained. She can have him placed literally next door in the holding cell where his attorney can still reach him, but where he has zero ability to stall, perform, or play games. This is the judge essentially saying, I've been patient. I've been fair. But we are now entering a new phase. And here's the question I want you to weigh in on in the comments. Do you think the judge's approach here, threatening bond revocation as a behavioral deterrent, is the right call? Or does it cross a line? Sound off below.
Discretion to control those proceedings. You right now, Mr. Hart, are free on bond. I don't particularly have any care as to whether or not you're free on bond or whether or not you sit next door, except to this point. For today, I'm going to expect that you disagree with my decision on your motion to have you represent yourself. I'm going to therefore excuse any further appearance of you for purposes of today's hearing and today's hearing only. I'm going to set this matter for a new hearing after I hear from your attorney and from the prosecutor. That new hearing is going to be set in person. The reason I choose in my discretion to set it in person is because if you're disruptive or unduly burdensome to the court at the next hearing in person, I'm going to view it as a violation of your bond conditions. And if I view it as a violation of your bond conditions, you're going to be subject to the contempt powers of the court, which includes me revoking your bond and you sitting next door. Because if I have your bond revoked and you're sitting next door, I'll know that Mr. Seeger can locate you and communicate with you. And if you have your bond revoked, I'll know that I'll be able to better control the situation than I can over an electronic communication like we're doing now. Because as you've demonstrated, the only way I can control the proceedings right now is to mute you so that you can't speak over me. That's not an effective way of running a courtroom, but it's the only way that I'm given your attitude, experiences, and your frustration. Mr. Seeger, did you wish to make a responsive record?
No, Your Honor, I do understand the court's ruling and I clearly will abide by it. Be that as it may, Your Honor, and I will discuss this with Mr. Hart. There was an amended offer that was extended, which.
Can you please speak up so that Mr. Hart can clearly?
Sure, Your Honor. There was an amended offer that was extended, which is much more favorable than the previous offer. I will discuss it with him. He can determine how he wishes to proceed.
All right. Did you want to, for purpose of the record, state that offer on the record?
Your Honor, my understanding is that he could plead to one count of attempted resisting and obstructing, which would be a misdemeanor in lieu of dismissal of the attendant charge together with the habitual offender notice.
What was the habitual offender notice that was charged?
It was this. I don't have it in front of me, Your Honor, because I just had the motion.
Your Honor, he's subject to a habitual 4. I believe it's on the information.
And I just didn't have the file in front of me, but do you disagree with that, Mr. Seeger?
No, Your Honor.
All right. So, Mr. Hart, it's very important that you not only hear the offer that's been made as an offer to an attempted resist and obstruct charge for dismissal of the existing charge as well as a habitual 4th, but it's fundamentally even more important that you talk to Mr. Seeger about that. He can give you advice. You ultimately get to decide how to proceed, and it does not matter to me how you proceed, so long as you proceed with the understanding that court procedures require structure, and that structure will be followed by you and by anyone else that's in this courtroom, or there will be alternative options considered by the court. Mr. Ziegler, anything further on any of that the people would like to offer?
No, Your Honor.
No, sir.
All right. The court will set this matter for a status conference next month. I will require that everyone in this matter be in person for the reasons I've already explained. Mr. Hart, you're free to sign off now. I expect you'll talk with your attorney and be here in person next month. You'll get a notice in the mail.
And there you have it, one of the most controlled, methodical judicial takedowns of a sovereign citizen strategy we've seen on film. Let's recap what happened in this courtroom today. Ryan John Hart appeared before a Michigan judge for a hearing on a motion to allow him to fire his attorney and represent himself. From the jump, he refused to straightforwardly confirm his own name, attempting a classic sovereign citizen move to separate his living self from his legal identity. The judge wasn't fooled for a second. She then delivered a multi-pronged legal ruling denying the self-representation motion, citing 3 independent grounds under Michigan law and the People v. Anderson standard: no unequivocal request, no knowing intelligent voluntary waiver, and a firm finding that Hart's behavior would unduly disrupt the administration of justice. She also exercised her discretion under Michigan's rules of professional conduct to keep attorney Mr. Seeger on the case even against Seeger's own motion to withdraw. On top of all that, the prosecution disclosed a new, significantly more favorable plea offer, a misdemeanor plea to attempted resisting and obstructing, with dismissal of the felony charge and the habitual offender enhancement. That's a massive deal, and Hart needs to seriously listen to his attorney about it, whether he likes it or not. The bottom line? This judge ran an airtight hearing. She was patient, precise, and utterly unintimidated. She gave Hart every opportunity to engage in good faith, and when he wouldn't, she used every tool the law gave her to maintain order. That is what judicial excellence looks like. If you found this case as shocking and fascinating as we did, hit that like button right now, drop your thoughts in the comments below, we read every single one, and make sure you subscribe so you never miss another jaw-dropping courtroom breakdown. We cover the cases the mainstream media glosses over, and we break them down so you understand.